welcome to another of our series on how public benefits support employment. Scott and I will be covering a lot of information today, but we're going to start off first with telling you who we are and why we are interested in this topic. I'm Susan Harrell, and I work at WISE. I've worked there for the last 20 years, but I actually have 35 years in the field of disabilities and employment. So I really have been focused on trying to help people understand how to make employment work and to reap the benefits. And along the way, a piece of that work has been around Social Security and medical benefits. I found that those are really important topics for people. So I have worked on training professionals in that topic, as well as helping individuals and families understand what's going on with benefits through presentations, as well as with individual work. You want to introduce yourself, Scott?
Yeah, hi everyone. My name is Scott Leonard. I've worked in the field of supporting people with disabilities for over 20 years. And for about 15 of those years, I've helped people navigate through the different government benefit systems. And I'm actually really excited today to be talking about Title II benefits. I think people have a lot of questions about Title II benefits. It's not very clear to them when they become eligible for those benefits, how those work, and how wages are viewed in regards to those benefits. And so we'll have an opportunity today to explain all that to you.
So for our agenda for the day, we're going to be giving you an overview of Title II benefits and kind of helping you see the framework of these benefits versus the Title 16 supplemental security income benefits that we spoke about in the previous webinar. And then we're going to go into talking about Title II benefits and how earned income impacts those benefits. We're also going to be talking a bit about unearned income when it comes to these benefits and providing you with information about where that falls, how it is seen. And then we're going to dig into substantial gainful activity, or SGA, work incentives that really help promote the idea of work and help people maximize their benefits at the same time as they're experiencing work, and talk about what is countable income when it comes to Title II benefits. And then we're going to start talking about the ways in which people need to report their earnings and helping them to think about the framework for record keeping. We have some tips and tricks and ideas about ways in which people can be effective in tracking and keeping those records so that they're able to utilize those if they're ever at a review point. So why is understanding Title II benefits and work incentives important? This is, again, one of those things where the work that we do is really surrounding helping people address their fears and helping them to understand exactly what is going on with their benefits, and in relationship particularly to work, what's going to happen. We really find that reduces those misunderstandings and myths that people have that seem to spread like wildfire. Once one person has an experience, they sometimes convey information that may not be entirely accurate, and that word spreads and the fear spreads. We also really want to address preventing the possibility of a crisis because more information tends to help people remain safe when it comes to not getting into overpayment situations with benefits. And then we want to help people understand how they can earn and save money and still remain eligible for essential benefits. Maybe they move away from some of those public benefits because work provides more for them. But there are essential benefits that sometimes people need to remain eligible for, and there are ways in which you can do that. We also want to really ultimately help improve employment and economic outcomes. We want people to be able to have wealth, to be able to grow their savings and grow their earnings over time. And we know from a study that the state of Vermont did many years ago around benefits planning that benefits planning is effective in increasing those employment rates and increasing earnings, and also in decreasing medical expenses, because helping people go to work is healthy. It helps them to actually reduce their need for some of the medical services that they receive. So it's a good thing.
So let's just do a sort of a high level overview of Title II benefits, okay?
Great.
So we're going to start off by just talking about the history of Social Security, just briefly, because it creates a context in understanding this benefit for people with disabilities and how it differs from, say, SSI. So Social Security didn't begin until 1935, and it was in response to the Great Depression. People had spent their lives working, saving money, investing money, and then when the Depression hit, people lost some or even all of that money. There was no safety net, and there wasn't really a retirement benefit to help people. And so that's why they created Social Security. So now when we pay our FICA taxes, we're paying into our retirement. So when we hit retirement age, we may be eligible to collect some retirement benefits.
Yes.
So at the time, there was nothing really available for people with disabilities. That didn't happen until 1954. In 1954, they created Social Security Disability Insurance, or SSDI, and we're going to be talking about that benefit today. SSDI is for people who've been working, paying into Social Security, and now their disability affects their ability to work. They may be eligible for some SSDI. At the same time, in 1954, they created a program called Disabled Adult Children, or DAC, is how it's commonly referred to. Now, disabled adult children is a benefit for people who have a disability, but it started when they were younger, under the age of 22, but now they're an adult. If that person's parent retires and collects benefits from Social Security, or becomes disabled and collects benefits from Social Security, or if the parent dies and could have qualified for Social Security, the adult son or daughter can actually collect a benefit based off of the parent's work history. So those are Title II benefits, disability insurance, and disabled adult children. That's what we'll be focusing on today. And then in 1974, supplemental security income got going. It was actually signed into law until 1972, but it didn't really get going in the country until 1974. It's different than SSDI. It's not focused on a person's work history as much as a person who is aged, blind, and disabled, and they have economic need. So they need some money to pay for their basic food and shelter costs. And we have a whole nother training that we've done on supplemental security income. And if you want to know more about that program, we welcome you to listen to that. So let's just talk a little bit about the definition of disability. And disability is one of those things we could talk for a long, long time. We're just going to do, again, a very sort of high-level overview. But a disability for Social Security purposes is defined as a couple of things. One is that it's considered substantial. It results in the inability to work at substantial gainful activity. And that's a term we're going to be talking about a lot today.
Right.
So if you look in the corner, there's a box there that reads SGA 2019. SGA is the term for substantial gainful activity. And we put in 2019 because we see the amount for SGA change each year. It tends to go up each year. So for 2019, for someone who is not blind, if their earnings are at $1,220 gross per month or more, they could be considered by Social Security as performing substantial gainful activity. Right. If someone is blind and their earnings are at $2,040 or more, they could be considered earning substantial gainful activity. For people who are blind, SGA is much higher.
Right.
Okay. So a disability needs to be considered substantial, which is the inability to work at substantial gainful activity. And the disability needs to either be terminal or long-term. So terminal means, of course, that it would result in death, or it's long-term. It has lasted or can be expected to last for a continuous period of not less than 12 months. Okay. So what we see with some benefit checks like SSI, substantial gainful activity is only really considered at the time of application, and then Social Security doesn't care too much about it. But with the Title II benefits that we're going to be talking about today, we're going to be focusing on SGA. What does SGA mean? When does Social Security look at it? And what happens to a person's benefits when they perform SGA?
Great. All of this information does raise a couple of questions.
Yeah.
I have people ask me, why is it that blind and non-blind SGA are so different?
Right. Yeah. So my understanding is that people who are blind had really good lobbyists, and they just created a different set of rules within Social Security for their benefits. So this is a perfect example. They can earn $2,040 without being considered earning SGA. And there's also work incentives that are specifically carved out for people who are blind for some of the other benefit programs.
Right.
That's the story I've heard. Have you heard the same thing?
Oh, yeah. And I do get asked that question quite a lot. So I figured I'd just play the audience for a bit and throw that out there.
Yeah.
There's another question that I get asked, or maybe it's more like a scenario. Okay. And that is, I'm driving and I get in a car accident. And let's say that I end up having an injury that causes me to not be able to work for quite an extended period of time.
Yeah.
So I'm not able to work at substantial gainful activity.
Right.
And let's say that it's expected that I won't be working for 6 to 8 months. Does this, what you're saying here about the measures of disability and the definition Social Security has, does this mean that I wouldn't be able to apply for Social Security and get benefits if my injury kept me from working for that 6 to 8 months?
Well, I think people should apply if they have any concern about that. I don't think they should necessarily interpret that and say, I'm not going to apply because it's supposed to just be long-term, meaning it's going to last for at least 12 months or longer. I would encourage people to apply. And they may have evidence to show that, yes, they may in fact improve within 6 to 8 months, or they may not. And so part of the application process with Social Security is creating the argument of what is the disability and how does it affect your ability to work now and how you project in the future. Right. And if that information is supported by letters, say, from doctors or even individuals who know you, that information could really influence Social Security to say, yeah, I think you're eligible for Social Security benefits. What do you think?
Yeah, I think it depends on what recovery looks like for that individual and what doctors have to say about the prospect for recovery, because you do still have to meet both measures. It needs to be long-term or terminal or long-term, and it also has to result in not being able to work at a substantial gainful activity level.
Right.
And so meeting both of those measures, it's not as simple as people make it seem on the face of it when they say anybody can get Social Security. You definitely have to show, you have to prove that you meet all of that definition of disability.
Exactly. I think for some people, they know that they are going to recover within 6 to 8 months, for example. Chances are they will not qualify for Social Security in that situation. But a lot of times it's just not clear, is it?
Right.
And so again, it's that information and that you get from doctors that you provide to Social Security. And then they will make that decision.
So I want to talk a little bit about the Social Security disability-focused programs. And I really think about them in two different umbrellas. The first is Title II. This is the one we're going to spend a lot of time talking about today. And yet I still want people to understand that there's this other benefit so they can begin to sort out the differences in the benefits people receive. So this is Title II that we're focused on today. It's also known as Social Security Disability Insurance, or SSDI. There's also Social Security Childhood Disability Benefits, or SSCDB. And that's the benefit that you referred to being a part of the framework of the introduction of disability benefits within Social Security back in 1954. Right. And it was called Social Security for the Disabled Adult Child at that time. So there's been a movement of terms into this new Social Security Childhood Disability Benefits label for the original benefit for children, for adult children. There's another benefit here that we're not going to talk a lot about today, but I don't want to let it go unnoticed, that there is Social Security for disabled widows or widowers. Now, that benefit, the reason we're not spending a lot of time talking about it is specifically defined around an age group and a specific population. And so we don't come upon it very often. We felt like that was one of those things where if you needed more information about that, you could certainly contact us and we could help provide that. It still flows within the Title II program, still has the same measures in terms of earnings and work efforts and using work incentives and things like that. But it's a very small window that people have to fit into to be eligible for that benefit. Now, I also wanted to note that people tend to call Title II benefits SSA or regular Social Security.
Mm-hmm.
That's usually the way they label it when they are talking about this benefit, and it kind of gives us a clue at times about what's going on with their benefit picture. The other umbrella is Title 16 or Supplemental Security Income, SSI, which we did cover in the previous session and we have available for viewing. So if you're interested in that benefit, please feel free to let us know so that we can provide you with that information. But really, we're not going to be focused so much on that today. We're going to just look right at Title II and move through that benefit so that you have a more full understanding of that particular benefit for folks. So talking about qualifying factors, how is it that somebody qualifies? And this is really about how do they tap into the funding, right? It is funding that it comes through the Social Security Trust Fund. And that means that you have to be able to have worked and have insured status on your own record, or a parent or spouse has worked and has insured status, meaning that I'd be drawing off of their record. And that means that that person needs to be retired, deceased, or disabled. So they have to be actively drawing off of their own record or deceased, in other words, in order for somebody else to be drawing off of the record too. For instance, a spouse or an adult child under the childhood disability benefits.
So Susan, I have a question about this slide. What if someone has worked and paid into Social Security and they could qualify for SSDI, but they have a disability that started when they're young and their parents say has retired? Can they qualify for both SSDI and the childhood disability benefits?
It's possible.
Okay.
Yeah, the way that it works is they look at the highest benefit amount.
Okay.
Okay. And the priority is to have the person draw off of their own record. But let's say that we're looking at a child, an adult child that would qualify under childhood disability benefits. And the benefit the child could draw off of a parent's record would be, let's say, $1,500 a month. But on their own record, that child has worked enough that they could draw $1,000 on their own record. The way that Social Security does this is look at the maximum benefit amount of $1,500, but the first $1,000 is drawn off of the child's own record, the adult child's own record, and then the remainder would be added in from the parent's record. So sometimes that means that you see on an individual's letter a couple of Social Security numbers, meaning they're drawing off of more than one record.
I see. So they don't add those benefits separately. You basically get the higher of the two.
Exactly.
In the end, that's the most that you get. Okay.
Altogether. Yeah. And that's a common question. Yeah. I do get that quite a lot.
Mm-hmm.
So how much is the benefit? With Title II, it's very different than SSI. SSI, we know that there's a maximum benefit amount, as we spoke of last week. But with SSDI or SSCDB, so either drawing on your own record or drawing off of a parent's record, the benefit varies, and it is based on the insured worker's FICA payroll deductions and their work history, right? So there's factors that are involved, and it means that the computation for the actual benefit amount is it's very individualized. They look across time with the worker and figure that out. And you get a clue about it because Social Security provides statements about, how much you would draw at retirement, how much would you draw if you became disabled. They provide information, but that's really just a hint at what the amount might be. In the end, if you become eligible for these benefits, they go through computations and they determine the amount to be paid. And it may be a bit different than what you're seeing on those estimates that they provide you. The other thing I wanted to point out on this page is that we've made note of the medical benefit that's associated with each benefit type. So with Title II, Medicare is attached to that benefit. So an individual eventually, and we're going to talk about this more next week, but eventually they become eligible for Medicare if they are eligible for a benefit under Title II. So either SSDI or SSCDB, they would be connected with Medicare. Doesn't mean they wouldn't necessarily be connected with Medicaid, because sometimes people can carry eligibility in both programs, but the primary medical program that is attached to Title II benefits is Medicare. And you'll notice that with SSI, we made note of this last week, that Medicaid is automatically attached to the SSI benefit.
Susan, I have a quick question about this slide. You were talking about the benefit check depends on the person's work history and paying into Social Security. What if it's based off of a parent? Is it just based off of, do they get the full amount that the parent gets from Social Security? Or what would a person who qualifies for childhood disability benefits get if it's based off of a parent's work history?
It would typically be 50% with a living parent, but there are a number of things that are involved in determining how much the child gets, like how many other dependents may be drawing off of that record.
Okay.
And so, that's another thing that makes it a little bit hard to estimate, but the base is that it would be 50% typically.
I see. Okay. Thank you.
You're going to just really knock me out with all of these tough questions here early on. So what happens if other income is received? Now, this is where we start talking about substantial gainful activity,
Right.
as you spoke of earlier on when we talked about the definition of disability for application. And then you alluded to the fact that when it comes to Title II benefits, that substantial gainful activity remains, right? It's something that is a measure over time of whether the person can continue to receive the benefit. So if other income is received, it's really going to be measured against substantial gainful activity if it's around earnings. So earnings is really the important term here. It's a level of functioning that somebody has. Their capability to earn in a workplace is the way that Social Security determines if the person is functioning at a level that meets the definition of disability. And what they compare it against is this substantial gainful activity amount, which is $1,220 for 2019 if you're non-blind. For people who are blind, again, it's $2,040. But this measure is something that we're going to talk about more as we go along today, because it's very important if somebody's on Title II for you to understand that earnings are not necessarily the gross amount that they get in a paycheck, right, because it's about their level of functioning. And so there are a number of things that you can consider when you're thinking about whether they're earning the full gross wage amount that they get paid each month. And I think this is one of the things that is the most confusing piece for a lot of people. I have come across so many situations where an individual is being helped by professionals and they're told something that's sort of a rule of thumb statement, like, you'll be fine as long as you don't make more than $1,000 a month. Mm-hmm. Have you heard that too?
I have heard that, yeah.
And it's really a shame, because that's not really taking a good full look at the individual situation and determining what's going on in the workplace.
That's right.
When it comes to substantial gainful activity. And that means that we're limiting people and sometimes condemning them to live in poverty as a result of the lack of information that we have.
Oh, I totally agree with that. I think with SSDI and childhood disability benefits, much more than SSI, there's a lot of misinformation out there.
Right.
And a lot of fear about losing those benefits.
Right.
Yeah.
And you've noticed that none of these slides speak to resource issues, right? And I think we didn't even have that even as a piece of the last few slides. And the whole thing about that is that resources and that resource limit we talked about with SSI, it doesn't apply when it comes to Title II benefits, right? Not straight Title II and Medicare. When somebody's got that kind of a benefit picture, they don't have to worry about that resource limit. And yet so many people are told you can't have more than $2,000 in resources.
Right. And
that, again, limits their ability to live as completely and fully as they would be able to. So information about these things is really important.
Absolutely. And I've seen instances where people are told by Social Security, hey, you get SSDI, there is no resource restriction. but then they may have another benefit in their life, maybe from the state, that does have a $2,000 resource limit.
Right.
And that's just another example as to why it's really helpful to have a benefits planner analyze the person's situation and all of their benefits and sort of come up with the parameters of those rules.
Right.
Yeah.
And often a benefits planner has lots of strategies that they can bring to the table to help enhance the person's situation and allow them. Typically, it's to keep medical benefits that they're most concerned about, but allow them to be planful in moving along with their benefits picture in mind and proceeding to progress wage-wise, savings-wise, as they go along, as the rest of us want to do without all of those concerns.
Yeah. So now we're going to talk about earned income. We've already been alluding to it, but we're going to go into much more detail. We're going to drill down and talk about how Social Security views earned income and how that affects the Title II benefits. Okay.
Great. So it's obviously not such a simple thing, the way they view earned income. And so we are going to give you some examples, but I wanted to provide you with sort of a visual for those of you that are process oriented to kind of see the process for Title II and earnings laid out in this way. So we begin with the trial work period. And this period of time is a period of time when you're trying to get to 9 months, maybe not trying to get, but the measure is getting to 9 full months where you hit the trial work period amount. Now, this is the time when they measure gross wages. It's the only time that they're measuring gross wages rather than earnings. And during the trial work period, they measure it as, for 2019, $880 in gross wages. So every month that I make $880 or more during 2019, they would count those as a trial work period month. So this is confusing. And again, we're going to give you an example, but the idea is that across a 5-year period, if I get to a point where I have a total of 9 of those months where I've hit that trial work period, then this part, this phase in the process of moving towards working our way off of benefits, I guess, it will end once I hit that 9 trial work period months. And the thing is it's a rolling window of time, right? So they're looking across a chunk of 5 years and seeing if I hit 9 trial work period months. If I didn't, then they're going to move the window forward. And that window continues moving until I get to a point where I have hit 9 trial work period months.
That's right.
And I think one of the important things about this is that you receive a benefit check regardless of those gross wages. So I could be making $5,000 a month, and yeah, they're going to count it as a trial work period month because that's over the $880 trial work period amount. But I'm going to get my check. They're not going to just stop it because I made $5,000. Right. And so I consider this to be a great time for people to be able to test out employment, to see how it really works and see if they can get to a place where they can experience abundance with employment. And often what happens is that we're still limiting people and they're getting that rule of thumb, don't make more than $1,000 a month, even across this period of time when they could experience fully how employment might look for them.
That's right.
So that's the first phase. And once a person completes this trial work period, then they move automatically into a 36-month period called the Extended Period of Eligibility, or EPE. Now, this is when the measure is going to truly be substantial gainful activity as to whether the person receives a check or not. So typically, if I make more than substantial gainful activity in earnings, I won't get a check. But if I make less than substantial gainful activity in earnings, I will get a check. So it's off again, on again. It's clear cut. It's not like SSI where the check gradually goes down as your earnings go up. This is an on again, off again thing. And this lasts for 36 months. So again, you maintain eligibility if you are above substantial gainful activity and you don't get a Title II check. It's just this period of time when you don't get a check. And then the very next month, if you earn less than SGA, you get a check, right?
Right.
Kind of confusing, though.
It is confusing.
I don't know why they made it this hard, but they did. And then we're going to move into the post extended period of eligibility. And this is a period of time where they're going to continue to measure substantial gainful activity. But the thing is that if you earn over substantial gainful activity after this 36-month extended period of eligibility, when you're in this post EPE phase, benefits will terminate. So that's when everything is all done. And the trick is measuring exactly where somebody is with all of this.
Right.
And to make it even more confusing, Scott, they have this thing that I think is really considered a bonanza or a benefit, but it's called the grace period.
Right.
And the grace period is this, I call it almost like the Jacob's ladder thing, where you hold one card and two more fall down from that card. It is this 3 free months of benefits when you first earn above SGA, either in the extended period of eligibility or in the post-EPE, post-extended period of eligibility period.
Right.
So the first time I earn substantial gainful activity, I'm going to get a benefit check if I still have my grace period remaining. And the next 2 consecutive months, I'll get one as well. And this is regardless if those other months are above or below SGA. It's just like they throw in 3 free months, right?
Right.
And that will travel with me. If I don't use it in the extended period of eligibility, I'll be able to apply it to that post-EPE period. Now, this is also confusing, that it's always good to run through some examples, right?
Yeah.
Which is, I'm so thankful that we have those prepared to help people. But I'm going to look at you because I'm thinking you have questions. I can see it in your eyes.
Actually, I'm going to hold off on those questions because I think when we go into each one of these areas, we'll have an opportunity to talk about it.
Yes.
And then you can ask me some questions. That'll
be great. Okay. So here's the thing, though. This graphic is mostly to tell you that there is a process, and the process goes from the trial work period. And it's a non-consecutive period of time. In other words, we're just looking at a 5-year window when I earn over that trial work period amount in gross wages.
Right.
Then we move into the extended period of eligibility, that 36-month period, and it just automatically comes into play once I've finished the trial work period.
Yep.
And then once those 36 months are up, I move into this post-EPE thing.
Yep.
So that piece is fairly clear. But measuring how somebody is doing in each of those pieces is the part that becomes more confusing.
I totally agree. Yeah. I think this slide, that slide that we're looking at is really good. Is something that you print out and you hold on to.
Right.
Because it's a lot of information that we've condensed into one page. But for the purposes of this presentation, we're going to look at each one of these, the trial work period and the extended period of eligibility, and really drill down and understand what those mean. And then we'll talk just a little bit about the post-EPE and also the grace period.
Right.
Okay. So let's just talk about the trial work period now. Okay. So what we have here is a calendar. It starts in 2016 through 2018. And that will make sense as to why I did that in just a little bit. And we'll see in the right-hand corner, there's amounts listed for 2016, 2017, and 2018 for the trial work periods. There's 810 in 2016, 840 in 2017, and 850 in 2018. And we know that it's $880 for 2019, right? So what that shows you is that the trial work period amount changes each year. It tends to go up every single year. And if people want to know what the trial work period is going to be for the next year, they can always just do a web search towards the end of the year and just say trial work period 2020, trial work period 2021. And chances are the first thing that's going to pull up is something from Social Security that lists that trial work period amount. Right. And you can also find all the past trial work period amounts as well.
Right.
Right.
Yeah. While that change is a blessing, like it gives people a higher mark that they need to hit each year, it does make it confusing.
It does make it confusing. Absolutely. So let's pretend that this person is eligible for benefits. And we're just going to start looking in January of 2016. Let's say this person has SSDI, but they could also have childhood disability benefits, and they're going to follow the exact same rules, right? Even though that's a benefit that's based off of the parent's work history, They're still looking at the person's work. They're looking at the trial work period. All the same rules more or less apply.
Right. It's about that measure of disability.
Yeah. And like Susan was saying, the trial work period is a time when people can try to go to work. You can work and make any amount of money while you're in the trial work period, and you get to keep your full benefit check, right? They actually don't look at substantial gainful activity when you're in the trial work period.
Right.
So if I make $10 in the month, or if I make $10,000 in the month, and I'm in my trial work period, I get my entire Social Security check.
Right. It's great.
Yeah. So this is, as you said, a really good time for people to try to work, to try it out, right? So as you said, Susan, once you earn 9 of those trial work period months, the trial work period ends. Okay. Right. So in this example, in 2016, we started in January. Now the trial work period could have started in May or in October, but it's just is much easier to look at a calendar and start it in January.
For your convenience. Yeah.
So as you can see in that first year, there's just some wages that are earned in July, August, September, October. They're all pretty low. They're below the amount for 2016, which is $810 gross per month. And so that person did not earn any trial work period months in that year.
Right.
They get their full benefit check every single one of those months. Now let's go on to 2017. They start working, it looks in April and May. And then in June, they make more money than the trial work period amount. So for 2017, it's $840.
Right.
And you can see in June, July, and December, they made more than that amount of money. And that's why those are highlighted in red. So this person earned 3 trial work period months. Now in June, July, and December, they get their full benefit check. This is something that's just being tracked on paper by Social Security or in the computer, but they're tracking this in terms of where is the person in regards to the trial work period, but there's no risk at this time for this person to try to work and make money.
Right.
Yeah. You were mentioning this rolling year period, 5-year period. So let's say, for example, this person for 2017 at the end of December, they stopped working and they didn't work for the next 5 years, right? They're still in the trial work period. Right. So when we hit June of, that would be, I'm guessing 2022, they can only go back 5 years.
Right.
So then that 1 month in June where they performed a trial work period month, it falls off that person's record. Right. So now instead of having 3 trial work period months, they have 2 trial work period months. Mm-hmm. And then when they hit July in 2022, they would no longer look at the July in 2017. So they can only go back 5 years. It's like when you have things on your record that go away after a certain amount of time. That's exactly how this happens.
That sounds like you're comparing it to something else.
It sounds like a traffic ticket.
Yes,
something.
That's exactly it.
But this is actually something that's much more positive,
right?
Because we want something to work.
I was like, it's not so bad. It's a good thing.
Yeah. But that only happens when someone's in their trial work period. Because when you're done with the trial work period, they don't go back anymore and look at any of that work history.
Right.
I think of the trial work period and also the extended period of eligibility as being like a room. So when you're in this room of the trial work period within the house of, say, Title II benefits, these are the rules. But when you're done with the trial work period, then you leave that room and you take your keys and you lock that door and you go into the next room, which is the extended period of eligibility. And in that next room, there's a total different set of rules. Right. And I think that's helpful because you learn one set of rules for the trial work period, and then you have to learn a completely different set of rules around the extended period of eligibility. And it's easy to cross them over. So it's helpful just to try to keep them contained to the different periods, those rules. Right. Around income and how it's viewed. So let's come back to this example. So now we're going to move on to 2018. And what I've done here is I've highlighted all the months when this person was working. Those are their person's gross wages, where they made more than the trial work period amount in 2018, which was $850. You can see in January, August actually all the way through to December, the person was making more than $850 per month. Each one of those months is a trial work period month. And when they hit December, if you counted up all the months that are in red there, the months that they may have earned a trial work period month, that would be the 9th trial work period month. And that means at that point, the trial work period ends.
Right.
The trial work period is closed, person leaves that room, they lock the door, and then they're going to go into their extended period of eligibility.
Yeah. You know what I find interesting about this chart is here again, it kind of looks like the person is being cautious about going to work.
Right.
You know, that they really just, it could be that it's just the job that was offered and how much they can work. But it kind of looks like they were trying to maintain wages that were under substantial gainful activity, as we talked about before. And I see this and I think they didn't get good information about where they were in all of these phases so that they could really take full advantage.
That's right. You have to wonder about that. Was this person keeping their income below because they heard if they make too much money, they're going to lose their benefits?
Right.
Right?
Yeah.
That could be. And you do run into people who have made that decision based off of information that they've received from other individuals.
Right.
Yeah. It's a good point.
I also know that there are people that I've worked with, because the trial work period amount goes up year by year. It was quite low 20 years ago,
Yeah.
Right? And they may have been working and earning or hitting that trial work period amount as they were going along in their gross wages. And their trial work period was completed, and they moved into the next phase without any knowledge that they'd actually completed their trial work period. This happens quite a lot with people that I talk with that have long work histories that might be kind of sporadic.
Yep.
And I will ask them about work and they'll say they haven't worked. But when I look at their record, when I get the information from Social Security, I can see that they actually did work, but they thought it was minimal. Because we're looking back, and if trial work period amount was just a couple of $100,
that's right.
That doesn't seem like I really worked. Oh, I just did a few, odds and ends things here and there, and yet it measured it as a trial work period month years ago.
That is so true. I experience that all the time. And when you first start working with a person, unless you have information from Social Security, the person's kept really good documentation, you don't know where they are in terms of their trial work period or their extended period of eligibility. You just don't have that information. You have to really dig down and get that information.
Right.
Yeah.
Super important.
It is. And part of the reasons why it's not always so clear is the way that Social Security collects information about people's wages. And we're going to be talking about that towards the end of this training. Yeah.
Great.
Now, you notice that the trial work period ended in December of 2018. We did that because it's just really convenient to do that visually. The trial work period could have ended in August if August was their 9th trial work period month. But for this example, it ended in December. Okay. Because then we can jump into the extended period of eligibility. And it starts in January, and it makes it all nice and easy to talk about.
Exactly.
But in real life, it's not like that. So we mentioned that the person leaves the trial work period room, and now they go into the extended period of eligibility. Completely different set of rules, okay? The first rule is that SGA is now going to be considered. It wasn't considered during the trial work period, but it is going to be considered here, okay? And this 3-year period, this period, extended period of eligibility, is a 3-year period. So we show it going from January of year 1 through December of year 3. But if the extended period of eligibility started in July of year 1, it would then go through June, wrapping up 36 months.
Yes.
So it always lasts for exactly 36 months. That's the rule of the extended period of eligibility. And the way it works, and you talked about this, Susan, is that during this period, if someone earns more than SGA, they perform SGA, they may not be entitled to a benefit for that month. They may not receive a benefit check, right?
Right.
And that's kind of how it works. If you make more than SGA, then you're not eligible for a benefit check. If you make less than SGA, you're not performing SGA, then you can get a benefit check. This is what happens in this 3-year period.
Right.
Right. And you mentioned that there was also this period of time a grace period. And so let's look at this chart and we'll talk a little bit about this. Okay, so the extended period of eligibility started in January. Now you notice I just have year 1, year 2, and year 3. I could have put 2019, 2020, 2021. The problem is they're looking at SGA for the extended period of eligibility, and we don't know what SGA is for the next 2 years.
Right.
So for this example, we're just saying it's 1,220, which is SGA for this year for all 3 years.
It's like trying to untangle a really knotted up ball of yarn, isn't it?
Yeah.
Yeah.
So in this first year, if you look at the person's wages, all across the board there, that for that first year, they're making less than $1,220 gross per month. Okay.
Right.
So during that first year, they never perform SGA. That means for every single month, the person is eligible for a benefit check. Okay. Now we go to year 2. It's kind of the same situation. Now you can see in March, it looks like maybe the person lost their job and then they started working in June, and they may have lost their job again in September. But regardless, during year 2, they were consistently making less than 1,220. There's no month there where they made more than 1,220. And so they ended up being eligible for a benefit check for every single month, right? Then you go into year 3. Now, in February is the first month that the person performs SGA. It's 1,220, we'll pretend, in year 3. And this person made $1,350. Now, typically what we say is if you perform SGA, you don't qualify for a check. But as you said, the person gets basically, they get 3 months of benefits when they first perform SGA. That's why these are highlighted in blue. So February, March, and April, the person will receive benefit checks in those months. And it's triggered because in February was their first month that they had performed SGA. If the person had performed SGA in June of year 2, then that month and the next 2 months, that would have been their grace period, their cessation and grace period. You really only get one cessation month and the 2-month grace period once.
Right.
During this time, right?
Right.
Okay. So February, March, and April, this person still qualifies for a benefit check, with February being the cessation month, April and March being the grace period. But then after that, since that's all used up, any month where the person performs SGA, they do not get a benefit check. And those are the numbers I highlighted in red: May, August, and October through December. Those months, the person would not get a benefit check.
So I have a question for you, Scott.
Okay.
I see these numbers up here, and I am wondering, are these gross wages that you're showing in year 1, year 2, year 3?
Yeah, that's a good question. And we're going to talk more about how Social Security looks at wages, but generally, yes, they're looking at gross wages, and they're looking at wages that are earned in the month, not received. And that's where people kind of get tripped up. Right. So for example, if I get a paycheck on March 1st, it doesn't count for March, it counts for February because I earned that money in February. I think the easiest way for people to track this, and I do encourage people to track their wages when they're receiving Title II benefits, is to know their hourly wage and keep track of the hours that they actually work in a month.
Right.
And then that's how they'll know how much they earned in a month.
And that really provides a basis, because there may be some other considerations that reduce the amount of wages that are counted when it comes to SGA, because SGA is about what you've earned, not your gross wages.
That's right. That's right.
Yeah.
Yeah.
So it's kind of a trick, because in the trial work period, we're looking strictly at gross wages. Yeah. And in the extended period of eligibility, we're looking at earnings.
That's right.
Yeah. So it's kind of a moving target, isn't it?
It is. Yeah. It's a lot to keep track of. Absolutely.
I consider these benefits to be those that it's almost a given that if somebody really wants to go as hard as they can towards their ability to work and making more money and having the kind of career paths that the rest of us have, they really need benefits planning.
Exactly.
And that is a rule of thumb, I think, for people on Title II benefits, that benefits planning is an essential service if they're looking at maximizing the way that they earn money in the community.
Yes, I completely agree. So just a couple of points that we already talked about. As we said, this extended period of eligibility lasts 36 months. In this case, it ended in December for year 3. That was the end of the 36 months. And what happens after the extended period of eligibility is they go into a post-extended period of eligibility. All that means is that from that point forward, if the person earns SGA, they don't qualify for a benefit check, and they don't rebound the next month to qualify for a benefit check like they did in the extended period of eligibility. You see, during the EPE, you can get a check one month and not get a check the next month. Mm-hmm. Once you're done with the EPE, as soon as a person performs SGA, the benefits stop from that month and the remaining months forward. Right. So in this case, if the person made $1,300 in January of year 4, so they're outside of their extended period of eligibility, and they're over SGA, their benefits would stop. And then they wouldn't be getting benefits for February, March, April onward, right? I guess the only exception we would see to that is if someone hadn't yet used their cessation month and their grace period, because you always get that the first time you perform SGA. So if this person had never performed SGA during those 3 years, during the extended period of eligibility, that period still ends after 36 months. But then after the EPE, if they perform SGA, they get a benefit check for that month and the next 2 months. But then after that, their benefits stop.
And, that scenario where somebody is in the post-extended period of eligibility, and maybe they have achieved substantial gainful activity earnings levels in the extended period of eligibility, in that 36-month period, but it's been pretty sporadic. They get beyond the extended period of eligibility, and then they get a new job and they make over substantial gainful activity, and their checks stop, That scenario supports the stories that I hear about, hey, you just have to be careful because the first time I really worked, they stopped my check, And that's not the case if you map it out. But individuals are unaware that they're making their way through these various phases. As once you complete that trial work period, everything else is a consecutive thing. And so they could be well beyond the trial work period and the extended period of eligibility. And yes, indeed, the first time they work above substantial gainful activity, after those 2 phases are done, the check should stop. So it seems sudden, and it's really hard.
That's a really good point, Susan. And you do see that. And it's a good example as to why benefits planning should happen as early as possible and to get the most current information so you can start tracking from that point forward and have an understanding about what's going to be happening in the future if the person's performing SGA.
And you can see you really have to map it out. You have to put the numbers in. You have to try to figure out what everything happened because where it happens matters greatly.
That's right. So just to be clear about this, we were talking about if a person performs SGA during the post-extended period of eligibility, meaning the EPE is all wrapped up and you're kind of in that, you've left the EPE room and you've locked the door. Maybe you're outside the house now, or maybe on the front porch. If the person's performing under SGA, we'll say January of year 4 with this example. If they're under SGA, they get a benefit check. If they're under SGA for February, they get a benefit check. They continue to get benefit checks every month that they're under SGA. But when they perform SGA, that's when the benefits stop. And there's no safety net like the extended period of eligibility, at least not like as we've discussed here. Right?
They've made their way through these phases.
They've made their way through those phases.
And
now they're off of benefits. And I think of people who want to come off benefits, having this information and understanding that they can plan how they want those benefits, when they want those benefits to go away, right? They can be mindful about that when they're going to make that leap. And I think because Social Security benefits, these SSDI and childhood disability benefits are all or nothing checks, people need to sort of plan around that. They need to, by planning, what I mean is they need to know that when I accept this job, I'm going to be working full-time, for example, my benefits will stop, but when will they stop? And so they can be mindful of that.
Yeah.
Yeah.
I think that's really important. And I think it's important to convey information in such a way that as people are making decisions, this is part of that framework. Because I really believe that a lot of the time people do want to move away from these benefits if they understand the benefit of doing that, if they are able to work to their maximum capability and not be hemmed in, because this can be a ball and chain, really.
It can.
It can keep people from living the lives that they otherwise would want. And my experience tells me that typically an individual is willing to move away from this if they can maximize earnings. Their biggest concern is around medical benefits. And so if we can help secure those, and there are lots of ways to do that, as we'll discuss next week, they are able to plan to and eventually move away from reliance on Title II benefits.
Yep, exactly. So just one slide for folks to be aware of the increases that are happening across the state with minimum wage. So in Washington, in 2020, minimum wage is going from $12 an hour up to $13.50 per hour. And in Seattle, it's even greater. So right now it's $15 per hour for the largest employers. And then in 2020, it's going up to $16 per hour. So what's interesting about this is someone can be in their extended period of eligibility or their post-DPE, and they're under SGA. But maybe they're kind of close. And then 2020 rolls around and their wages go up, right? Suddenly they're over SGA, right? And now they're at risk of, they may lose their benefits. And maybe they're fine losing benefits, but that may come to them unexpectedly. That because their wages have increased, they're losing these Social Security benefits. And I think what's interesting about these Social Security benefits is that and the increase in minimum wage is that the person's work hasn't changed, right? The person might be working the same 25 hours per week, for example, making $12 an hour. They're under SGA, and all of a sudden a change happens with minimum wage. Nothing's changed in regards to their work, and now they're over SGA.
Right. I've had people ask me questions about that.
Yeah.
Like, is there a way for us to say it was just an increase in minimum wage? It really was a level of functioning kind of a measure.
Yeah.
And there really isn't, because the starting point is you look at gross wages and then we apply some work incentives to see what the actual earnings level is. But you start with gross wages. So as your gross wages go up, even if it's because of minimum wage increases, you've increased your starting point considerably.
That's right. So there can be an argument about whether or not that's fair. Those are the rules. And maybe there could be a conversation that happens maybe on a national level, because this is unique to Washington and a few other states where we're seeing such increases in minimum wage. Right. But at this time, yeah, that increase could push a person over SGA.
Right.
Yeah.
And so I put those on my pie in the sky list.
Yeah.
And sometimes my pie in the sky list delivers, right? So it's worthwhile to hope and wish and collect information, because we can sometimes speak into conversations about changes, right? And this is one that's been startling to people. And it calls for those individuals that are right on the line, it calls for conversations and meetings and really examining where they are, so that they can be prepared for these changes, because they're just right around the corner. So now we're working into work incentives that apply to substantial gainful activity, and really starting to dig into what is countable income for Title II benefits, right? So this is when, because we're measuring substantial gainful activity only at application, right, to determine if I've met the definition of disability. And then again, once I hit that 36 months of that extended period of eligibility, not the trial work period, but the 36 months, we're going to start looking at substantial gainful activity, and therefore we're going to start being able to apply additional work incentives to reduce the amount of countable income that would be compared to the substantial gainful activity amount.
Right.
So we'll be digging into that now. So what is countable income for Title II? And this is really about what you are considering when you're comparing countable income to substantial gainful activity. So I just charted out the calculation here and some considerations to work on when you're thinking about what's countable income. So we start with gross earned income. And you notice we're talking earned income. We're not talking unearned income. Unearned income is not considered here. So in this situation, it's unlike supplemental security income or SSI, that needs-based program we talked about previously. Unearned income doesn't matter. So I could win the lotto, or somebody could give me $1 million. I could inherit $1 million. And because it's not an indicator of my functional ability to work, my ability to work at or above substantial gainful activity, unearned income isn't considered. So all of Title II is really about your ability to function in a workplace. And that's what measures whether you're entitled to a benefit or not. So we start with gross earned income. And then we move into, does the person on that paycheck have sick, vacation, and or holiday pay? And that is reduced from gross earned income when we're thinking about earnings towards SGA.
What do you mean by that it's reduced?
So if let's say I take a week-long vacation in the middle of the month, right? Okay. So that's not part of my earnings picture during that month when it comes to SGA, because I'm off, I'm not working, right? So we're not going to count what my earnings were during that vacation or sick period or during the holiday. None of those things count towards my work efforts during that month because, hey, I wasn't working. I was in the Bahamas, with drinking umbrella drinks and soaking up sun. So that's not going to count when it comes to substantial gainful activity. Does that make sense?
It does make sense.
Yeah, and the umbrella drinks and stuff like that are sounding good during the rainy weather as well, right? So this is a piece that people miss often, and Social Security misses often, because you have to really dig into the pay stub to see what it is that it is part of the gross earnings, right? So it's important to get detail.
Yeah, and when I'm working with people, and I know we're going to talk a few slides about how people should manage all their documents and records and keep track of that information, but I do encourage people to keep track of sick time, vacation time, and the holidays, right?
Right.
Because sometimes Social Security doesn't catch that information.
Often they don't catch it. Yeah, right. They just look at the gross wage amount.
Sure.
And then some other factors, but this piece gets missed very frequently. And then we also can reduce what's considered as countable earnings by something called subsidy, as well as special conditions. Now, we've lumped these two things together, but these are the supports that somebody gets in a workplace, like extra supervision from, let's say that a coworker or a supervisor, or maybe an owner of a business even, spends extra time above and beyond what they would spend with someone else, with me as the individual worker. Well, that would be considered to be a subsidy. In other words, I'm getting extra assistance in that workplace in order to be able to make the money I'm making. And we can reduce from the gross earned income those kinds of supports in the workplace when we're looking at my level of functioning, my countable earnings. So there's supervision, job coaching, or lower productivity that maybe that the person works more meticulously and slower at a particular task than compared to a coworker. That would be part of the subsidy equation. Might have fewer duties. I might need to take extra breaks during the workday. Or it could be that I take special transportation to work. And that means that sometimes I'm a half hour late in arriving at work, or that maybe my dial-a-ride bus shows up a half hour early before the end of the workday. And that isn't reduced from my earnings when it comes to how much I'm paid in that workplace, but it should be reduced from my actual countable earnings when it comes to what Social Security is comparing to that substantial gainful activity number.
I see. So they're gathering this information, say about a person's productivity, to understand, to get a better sense of their ability to perform substantial gainful activity.
Right. It's about what they perform,
what they perform. I see.
Yeah. And it's interesting because this gets touchy.
Yeah.
Sometimes people are thinking that if you collect this information from an employer, that it could put the person's job at risk, right? And the point that I make to individuals is that a person's value in a workplace isn't just about how fast they work.
Right.
It's about other things they bring to the workplace. It could be good work ethic. It could be that they are very meticulous and very precise. And even though they work more slowly at something, that they're actually far more accurate than the coworker. And Social Security isn't looking at that piece. They're strictly looking at how fast is the worker working? How much do they produce? Not so much the value of what they bring to the workplace, right?
Gotcha.
The value in terms of maybe some of the things that lead the workplace just to be better overall as a result of their efforts. And that's what I promote when I'm talking with employers or with individuals about digging into this information and trying to really figure out, as far as Social Security is concerned, do I need extra supervision? Do I work more slowly? Do I need to leave early sometimes because of a transportation issue and it doesn't impact how much I'm paid, but it certainly impacts in Social Security's eyes how much I earn.
Right.
But it is a delicate situation, I think, to be able to explain that and effectively navigate those conversations that need to be had about this. And then finally, gross earned income is going to be reduced by IRWEs, impairment related work expenses. And this came up as a work incentive in our prior presentation about SSI.
Right.
It is an allowable deduction even for Title II benefits like Social Security disability insurance and childhood disability benefits. And so being able to try to figure out if the individual has expenses that relate to their impairment and relate to the workplace, and to submit those to Social Security may substantially reduce the amount that is countable as earned income towards SGA. And we're going to be talking about that more in just a little bit here. The other thing is, and this is something we're not going to spend a lot of time working on, but Social Security can average some months in which a person is making SGA versus other months when they're not. They could average across months. That's a little bit complicated. It takes a benefits planner and Social Security to navigate those things. The other thing is that sometimes people work above SGA for just a really brief period of time. It might be 3 months that they do that, and then their condition worsens and they're not able to work above SGA. Now, sometimes Social Security will waive the effort that somebody has made that would indicate they've worked over SGA if it's 6 months or less. And even better if it's 3 months or less, because it's a much simpler process. So if it's an odd thing in comparison to their overall work efforts, sometimes SGA can, that they worked over SGA during a few months could be waived by Social Security as counting. Yeah.
I see. And that those are decisions that Social Security makes, the averaging or having this unsuccessful work attempt. Social Security makes the final call on that. Is that correct? They
do.
Yeah.
And, mostly we make mention of it here because you really do have to take a look at the situation.
Yeah.
And sometimes a benefits planner can help with that. But these are things that are the things that come up once in a while.
Sure.
But they're facts. This is part of what can happen for someone. And we felt like we'd be remiss if we didn't mention it at least briefly.
Right.
So impairment-related work expenses. Now, this is going to look very similar to what we talked about with SSI because, indeed, the definition of an impairment-related work expense remains the same whether I'm on SSI or if I'm on a Title II benefit like SSDI. Impairment-related work expenses are those expenses that an individual pays for out of pocket. So it's an incurred expense. It doesn't get reimbursed from some other source. And we can tie it to the individual's impairment as well as their need to work, right? So it supports them in work given their impairment. And the other couple things are that it has to be reasonable, right? So if I pay for a limo ride to work, that's probably not going to be approved as an impairment-related work expense if there is a more reasonable, lower cost option available to the individual.
What if someone, say, needed a uniform for work? that qualify as an impairment-related work expense?
No, here's the thing is that I couldn't relate it to impairment if everyone needed that uniform for work. Now, let's say that the uniform needed to be modified, though, because the person had issues with, let's say, motor skills, right? Being able to fasten the fasteners or being able to utilize it, given something about their impairment. And we needed to have someone go in and tailor it, especially for that individual. That would make it related to work and related to their impairment because it's very different than what another individual in that workplace would utilize in their uniform. So if it's typical in the workplace, then no, you can't really tie it to the impairment. But if it's something that has become specialized because the individual has an impairment, it certainly would be an impairment-related work expense in that situation. And really, you get better at this as you go along because there are a lot of situations that come your way where you take a look at it. And I just tell people to think about it being something that is, kind of tying a bow, that you need both loops. You need that it's related to work and you need that it's related to the impairment in order for it to actually work. And here is the thing, is that when an impairment-related work expense is approved, it can be deducted from that gross wage amount when we're comparing the countable earnings to substantial gainful activity. So it's a really useful tool. Mm-hmm. I've seen people use impairment-related work expenses to pay for their own job coaching in a workplace. It's really effective. I've also seen them use it for specialized therapies that enhance their ability to do the work in the workplace, or even at times special equipment. Like an individual has a clerical job where folding is a very important factor in providing information packets. It may be that the individual buys something that allows them to fold things effectively and efficiently, and they utilize that in their workplace in order to enhance their performance and accuracy. And because we can show that they need it given their impairment, it works well as an impairment-related work expense. So you can be quite creative with these, and they are not time limited.
Right.
So I'm going to go over this example, and then Scott's going to sketch it out given what we've already been through.
Sure.
So let's say that Jared earns $1,300 per month in gross wages, and that he has $175 per month that he pays for out of pocket in medications and counseling services. So what we do is we start with this $1,300 gross wage amount, and we subtract this $175 in what we're going to call an IRWI, because we tied the medications and counseling services to his impairment as well as to his job. Mm-hmm. That means that countable wages are $1,125 instead of the $1,300 gross wage amount for Jared. So after that impairment-related work expense, that would bring his wages, his countable earnings, not his wages per se, but his countable earnings below substantial gainful activity. So that means that he didn't rise above it. If he were in the right phase, his benefit check would continue. If we're measuring SGA, then his benefit check would continue in this scenario.
Right. And this is going back to the example that we had earlier. So that's the whole year that we had it prior, but let's just focus on year 3, because year 3 was the year that we saw this person who performed SGA, right? It's the last year of the extended period of eligibility. And we can see February, March, and April was the grace period, the cessation month and the 2-month grace period. So let's say now that's when a person does not have an IRWI, but now they report the IRWI. Maybe they've had an IRWI all along and they just learned about this, and so they report it to Social Security. So what Social Security does now is they subtract from earnings, like Susan said, $175. And you can see below the difference. So for example, in January, where they made $1,200 gross per month, it actually looks like $1,025 in Social Security's eyes after they subtract that $175 IRWI.
Right.
And you can see February, March, and April, that would have been the time when the person first performed SGA and they had that grace period. But
Right.
actually, when you subtract the 175, they're still below SGA. They don't use their grace period. They continue to receive their benefit check. And all those months that were in red when they performed SGA, they would not have been, this person would not have been entitled to a check for those months. But with the IRWI, the person qualifies for a check each of those months because that IRWI brought them below SGA.
Right.
So it's really powerful.
It is.
And this IRWI can extend after the extended period of eligibility, right?
Right.
So this, we're giving an example of the 3-year extended period of eligibility. But if we moved on to January of year 4, the person's now done with that EPE, they can still apply that IRWI to make a determination if the person is performing SGA.
Right. And, you know, the interesting thing about this is that this is not uncommon, that we come upon a situation where somebody is just reporting and they're not including an IRWI.
Mm-hmm.
They do not know about it.
Mm-hmm.
And the thing is that Social Security wouldn't typically know about it, right? So who does know about it? Like, where do you find this information to help support the individual?
Well, that's a good question. I mean, I think that's a good reason why people need to talk to a benefits planner, because the person is likely paying for something that they have no idea that it's an IRWI, and Social Security, like you said, doesn't know, so they're not letting the individual know. But as a benefits planner, it's one of the questions that I ask when I meet with folks, right? Are you paying for anything that would qualify as an impairment-related work expense? Or is there something that you could pay for that would qualify as an impairment-related work expense?
Right.
Because people don't realize how it can affect their benefits. And there may be things that they need to pay for that they've made the decision not to, without understanding the benefit it can have on their benefits.
Well, and I also do a lot of training for individuals and families, as well as for employment providers, right?
Mm-hmm.
Those folks that are supporting someone in getting and keeping a job over time. And I think sometimes they know about things. And if we can teach them to be focused on this and thinking about this as they're planning their career, as they're thinking about what their earnings level is going to be in employment, that these things can come into play, and awareness makes a big difference. So my hope would be out of these trainings that not only do we get employment professionals that begin to look at this and think about the way in which this might impact someone, but that they also share this information in the form of the recordings with individuals and family members, if they have family members that are supporting them, so that you're really helping people to become more effective in advocating for themselves, right?
Mm-hmm.
So now we're going to talk about subsidy and special conditions. We talked about that in that chart where I started with the gross wages and started to talk about what could be deducted when we're thinking about substantial gainful activity and countable earnings. So when we think about subsidy and special conditions, this is where we're starting to focus in on the extra support that somebody's receiving on the job, or the lower productivity that they may have in the workplace. It could be that they're actually working less duties too, because that's another potential area where you can be looking at subsidy.
Mm-hmm.
Let's say that there are some duties that other workers that carry the same title in the workplace as I do, that they are performing, and I am not, because maybe it's answering multi-line phones, right? That I do a lot of reception work, but I don't answer the multi-line phones. So that might equate to a substantial part of my job that I am not performing, where other workers are expected to be bouncing back and forth. So those are things that are really important to report to Social Security in terms of the work situation where jobs have been customized. So typical in supported employment that we do that. And then if the person's taking frequent breaks, or they're arriving late or leaving early, or they have appointments or something like that that is interrupting the workflow, those are some things to consider. And I want to note that extra support received on the job could be provided by the employer, but it also could be provided by a job coach.
Mm-hmm.
So making sure that you gather those details is important. And ultimately, Social Security puts a value on all of these things, the subsidy and the special conditions. They value them and give them a dollar amount, basically, right? And then they would reduce whatever that amount is of these subsidy and special conditions from the gross wages before they arrived at countable income to compare to SGA. And I also wanted to note that there is a similar version that applies to self-employment situations. And this presentation is not about self-employment,
Right.
but it's important to note that there are similar things that can apply in self-employment and reduce the countable earnings, right?
Mm-hmm. That's right.
So we're going to go back to Jared, right? And we're going to say that he has an earnings level of $1,300 in gross income per month again, and that we've done an analysis of the subsidy and found out that Jared is assisting 25% fewer customers than other coworkers, right? So that's our estimate based on our observations in the workplace. Often job coaches do this, where they kind of take the measure of looking at one worker and then looking at Jared so that they can come up with, what are we looking at in terms of productivity, right? But it could come from a coworker or a supervisor as well. So we take this $1,300 in gross wages and the subsidy at 25% of the value of the work that is not performed really equates to $325 each month in value, actual value. So we're going to subtract that from the gross wages, and it brings us down to $975 in countable wages, or I'd really say countable earnings, because we're really talking about what is countable in your earnings, your ability to function in the workplace to compare to SGA. So after the subsidy, the countable wages are below substantial gainful activity. So the benefit check continues.
So the person's earning $1,300 gross per month, but Social Security is only looking at $975. This isn't taking any money away from the individual.
No, it's nothing the individual's paying for in this situation, unlike the IRWI.
This is just something to help Social Security make a decision about their productivity.
Right.
Okay.
Now, I have to say that I have had people say to me that they think this is money laundering or something nefarious when we try to figure out what are countable wages and we apply subsidy or special conditions. And the thing that I think really needs to be stressed here is that substantial gainful activity, while it is attached to an amount of money, is not really about the money itself. It's about a level of functioning. This is a measure of the level of functioning a person has, their capabilities in the workplace, and they just happen to use earnings as a way to try to figure out what that is.
Right.
So there is nothing wrong with being able to look at this. And in fact, it is really important because if the person still meets the definition of disability, meaning that they're working below substantial gainful activity, they have a right to these wages. They have met the standard as far as Social Security is concerned. So it's important for us to make sure that Social Security has all of the information in order to evaluate the situation.
That's right. I've seen instances where Social Security sends a letter to the employer, and they're asking for this type of information. And I know at the beginning of the letter, it will say, this is not about the person's value that they bring to the job, right? To the employer, but they're just trying to get dialed in on what is that person's productivity. But I also know that employers are hesitant to sign anything or put any documentation that a person's productivity is less than 100%. And so that can take some education with the employers. And you were mentioning how an employment specialist and job coach can be involved with this process. I think that that's a great place where a job coach can be talking to the employer if they get one of those letters and say, it's okay to fill that out. And let's try to figure out what that percentage is.
Right. Yeah, they can really engage them and they can reinforce the individual's value in the workplace as well at the same time.
That's right.
But these things happen. Whether an individual really wants the employer to get that letter from Social Security or not isn't really the option, right? So preparing employers, preparing the individual, letting them know that this is a piece of what will happen if they begin to look like they're working over substantial gainful activity is really important.
Yes.
Just to get everybody prepared.
Yeah. So this is just that example that we were using earlier. And this is going to look very similar to what we did with the IRWI, but it just shows how the wages and then the subsidy considered affect the person's earnings in relation to SGA. So this is the example looking at the person. They're in their extended period of eligibility. Same year 3, you can see the months where the person was performing SGA. That's without a subsidy.
Right.
The subsidy was probably existed at that time, but Social Security just didn't know about it.
Right.
So now you bring it to Social Security's attention, and they do the calculation of, okay, there's a subsidy of 25%. So we're going to subtract $325 from each month when we're doing this calculation. And you can see the difference. It's pretty dramatic. If you look at February of year 3, even though the person made $1,350, in Social Security's eyes, they only made $1,025. That's considerably less.
Right.
And you can see for that entire year, there's no month now where the person performed SGA.
It makes a huge difference.
Absolutely. And then the 3-year extended period of eligibility, it still ends after 36 months, right? It ends. No subsidy or IRRI can prevent an extended period of eligibility ending. It always just runs 36 months and then stops, right? You leave that room, but you can still keep applying that subsidy.
Right. You could be sitting on the porch of the house still, even if you've had to leave the extended period of eligibility room.
Yeah.
Yeah. You're still at the house.
Right.
Just hanging there, waiting for that moment when you earn over substantial gainful activity. And that could go on forever.
Forever. Yeah.
Right.
Mm-hmm.
I do have another question.
Okay.
So we're applying this during year 1, year 2, year 3, right? And we're taking a look at what it does to substantial gainful activity. Well, what about the trial work period? What does it do in the trial work period to have this subsidy or an impairment related work expense? How does it work there?
Yeah, it's a good question. Actually, it does nothing during the trial work period. And the reason is because Social Security is not looking at SGA when the person's in their trial work period.
Right.
They can make as much money as they want, and there's no risk of losing their benefits.
Right.
And so IRWIs, subsidies, they don't consider them.
Exactly.
It will not lower a person's countable income so they can not, say, be considered as performing one trial work period month. They don't look at it. It's only when they first go into their extended period of eligibility and beyond that they consider these IRWIs and subsidies.
Yeah.
Once they're on benefits.
That does come up a lot of the time.
Yeah.
I think it's the thing about, can we hold it back? Can we just stay in the trial work period forever?
Right.
But it's gross wages that are considered during that period of time, not actual earnings compared to SGA.
That's right.
So yeah, this only applies, these things that we're talking about here in terms of work incentives only apply during the phase that starts with the extended period of eligibility and continues through that post-extended period of eligibility.
That's right. So reporting earnings for SSDI and also childhood disability benefits, they're both Title II benefits. So a person should report new work activity to Social Security by the 10th of the following month. Okay, and they can do that by calling the 1-800 number. That's 1-800-772-1213. And they can request a work report. And they can also bring pay stubs into their local office. Okay, so that's a way that they can report, say when they start a new job or they see a significant change in their wages. Those are ways that they could report their wages to Social Security.
Great.
Now, if a person is going to be using up their trial work period or they're close to the SGA, Social Security is going to do what's called a work activity review. We'll talk just a little bit more about that in the next slide. But we're talking about reporting earnings for Social Security. And what happens with Social Security, and I'm sure you've probably experienced this when you talk to families, Social Security will tell them, don't bother reporting income, we'll contact you.
Right.
Right? Mm-hmm. And that's actually startling to people who may have been on SSI and they report every month to then going over to SSDI, and now they're being told that they don't have to report, right?
Yes.
What happens is Social Security will pick times when they reach out to the individual and want to gather information about that person's earnings to make a decision about where they're at in terms of their trial work period or their extended period of eligibility, right?
Right.
But for people, all they hear is the message, don't report income.
Mm-hmm.
And so they don't. And unfortunately, they don't know the rules at the same time. So a person could be making quite a bit of money and not reporting it. That could go on for years. Maybe they go through the trial work period. Maybe they actually go through their extended period of eligibility and they should not be receiving benefit checks, but they weren't reporting. They weren't letting Social Security know. And Social Security is just taking a long time to check back in with them, right?
Right.
That creates not a very good situation for that individual. It can create an overpayment. And so we always tell people, at least I do, I'm assuming you do as well, report every month if you can. Even when Social Security says do not report income, it makes sense to report income every single month.
I feel that way because it's hard enough to manage everything in your life. And I really can imagine that having benefits be a part of your life and all of the weight of those responsibilities and tracking and everything else is so overwhelming that you're likely to set it aside and forget to look at it.
Yes.
You just have to get in the habit of reporting anyway. Even if you're told not to report, you're the one that's responsible if there's an overpayment. So it just makes good sense that you'd protect yourself and you'd report.
Absolutely. And that's a good reason why people should manage their benefits, as we have as the last bullet on this slide. People should understand the rules and manage their own benefits, right?
Yeah.
That's important.
Whenever possible.
Whenever possible, yeah. The work activity review process, I mentioned that a little bit earlier. Social Security sends out something called a work activity report. It's quite a long document. And at the top of it, they'll put a date. They'll say, hey, we want information going back to this date. It might be 6 months ago. It could be 2 years ago. And what they want is information about the person's monthly earnings. They want to know about employer history with some detailed information about that employer. And this is also where they gather information about, are there any impairment-related work expenses, and is there a subsidy?
Right.
In Social Security, if they find out that the person may have a subsidy, that's when they may reach out to the employer to get more information. But they don't always do that, do they?
No. Sometimes they suspect that there could be. And that's really the biggest deal, is maybe because of the person's work history, they can tell that they have been in supported employment or in a sheltered workshop or some situation that would indicate there might be a subsidy. And that triggers that decision to send that. It's really hard to predict.
Right.
Yeah.
Yeah. And so the person fills out all this information. They submit it to Social Security, and then Social Security reviews it, and they take the IRBs and subsidies into consideration, and then they send a follow-up letter that basically details their findings. They may say, you've used up 8 of your trial work period months, or this is, these months you performed more than SGA, right?
Right.
And so these work activity reports, they can happen at different times. There's certain things that trigger them, a change in the person's job or earnings, or if Social Security thinks that they're at the end of the trial work period, or they are at the end of the trial work period, or they suspect that the person may be getting close to SGA, that can trigger one of these work activity reports.
Right.
So how can you help?
So just briefly, I think that it takes a village when it comes to benefits. And so I'm counting on people as they start to learn about these things to begin to assist people, to begin to get the information out. And that means really to help people identify when there could be a situation where there's impairment-related work expenses or additional subsidies or special conditions that are happening in the workplace. Often that's a job coach, could be a coworker, could be a family member that observes that the person gets lots of support, or it could be the individual themselves. But like I said, I think it takes a village. And really thinking about the ways in which you, in your role, can assist with the employer getting the information as well as the individual to understand what's being asked of them from SSA, because that can be confusing.
Yeah.
I have looked at those letters, and there are times that I just think, wow, could it be any more unclear, right?
Yeah.
It's hard for people to navigate. And so the more that you can assist by understanding the situation and why Social Security would be asking for something, the better you're able to assist the individual as well as the employer.
Mm-hmm.
And, you may need to identify an employer point of contact, because you want to make sure that anything that is being asked of the employer goes to the person that will be able to actually answer the questions. So that means don't send it to a district office, send it to, a department manager that's working with the individuals, so that we're clear that the person has a full view of what's going on when they're providing information as the employer to Social Security. And then finally, I want to just talk briefly about record keeping. And I know we're running up against the clock, but I wanted to make sure that you knew about a way that would be relatively easy for people to track this information. And I really encourage people to keep a binder, like one of those college-bound notebooks that they utilize to keep records. And it's because it's skinny, it's cheap, and all you need is that and a roll of tape and maybe a pen. And what you do is, as you get a letter from an agency, whether it's about your medical benefits or about your Social Security benefits or about maybe your eligibility for other kinds of services that are in support of a disability, that you tape those letters on a page, turn the page, and there's maybe that you get a copy of a pay stub, and you reported it to Social Security, and you tape that on the next page, and you write the date that you reported, and then you turn the page, and the next page maybe you have a conversation with your employer or with Social Security, and you want to make note of something that is very important to consider when it comes to your benefits. And maybe it's vacation time or sick leave or something like that. You make a note, you write the date, and you continue doing that throughout until that book is full. You put the date you started it, the date you completed it, you put it on a shelf and open up the next one. And what that allows is the very next time Social Security asks you for information and they go back 2 years, all you have to do is go right to that particular notebook and go through the information.
It's so true. I was just working with a family and they have actually kept all their documentation, which is great, but they put it in boxes. And so they brought down 3 boxes, and we're trying to find one letter from Social Security over the last 5 years. Not so easy.
Right. Not
and
so
that can
easy.
create a lot of panic when you get a letter from Social Security saying, hey, we need this information going back, say, 2 years ago, and we want this by a certain time frame.
Right.
So having it organized like this is really helpful for folks.
It also helps you sometimes in waiving an overpayment for benefits.
Sure.
If information has been conveyed to you in such a way that it sounded like you were being given a piece of information that caused a problem, right? Then you have documentation of that, and it's credible. If you have this series of notebooks with all of this information, conversations with people, at state or federal agencies with the date and the person's name identified and all of the kind of outline of the conversation, that protects you. And it's credible because it's obvious that you've done that over and over again. You've been tracking, right?
That's true.
And you have your pay stubs, you can prove you reported. So those things really do assist individuals.
Yeah. Great. Thank you, everyone.
Thanks. Have a good day.